case item 17, second April 34 and 23, 11, 17.
Memo of appeal filed by appellant for the first appellate court. There was no denial with respect to caste of dependent guilty, which has been decided by the trial. And even in first appeal, in second appeal, there is no whisper regarding caste of any of the party. The appellant has not stated herein with respect to her caste whether the finding is wrong with respect to her caste has not been pleaded. In both the said deeds, caste has been mentioned with respect to Kurmi Mahato. So
It has been mentioned only Kurmi.
Kurmi and title Mahato, Anita Mahato, Devendra Mahato, by caste Kurmi. Pleading of either of the party is not with respect to caste, but it was never pleaded, but in argument it has been raised, and firstly it was raised in cross-examination of DW4, defendant herself, which I have earlier placed before Lordship. That with respect to permission, question was put, and permission was
Question was put to whom?
Question was put to Anita Mahato, defendant.
Yes. Whether any permission has been
Whether
taken.
any permission has been accorded with respect to execution of sale deed for the reason that they are belonging to EC caste. Therefore, the situation arises for putting of such type of question.
The reason has not been put in the question. It is only put whether permission has been taken.
Question has not been recorded, but from the reading of paragraph 19 of PW4, it may appear that such question was put and it was answered. Whatever answer she has given has been reduced into writing. And it is our
Para 18 or 19 of course.
para 19. Para 19. Please go.
18 has been. Take that.
19.
19. I've written
19. I am permitted to place plaint with respect to certain paragraphs, 3 or 4 paragraphs. Para 7, that the defendant and her husband Birbal Mahato had a greedy eye on the land property of the plaintiff since long. Defendant and her husband usually used to visit the house of plaintiff. Allurement and assurance were given to the plaintiff on the alleged date of registration of scheduled land in favor of defendant. The plaintiff was served with wine and country-made liquor. Wine and country-made liquor yahi tha. And he was intoxicated condition. He was brought Saraikela and his thumb impression were taken in various papers. though usually he signs and writes his name. Para 10, that the
एक
contents.
second, though usually he signs and writes his name as D.A. Mehto, but he was prevented to sign anything.
That the contents of deed were also read over to him. Nine. That the contents of deed were also not read over to him nor was explained on local language. He was also advised to give affirmative answer before year 11 important है. That the alleged thumb impression were fraudulently obtained by Ganga Saab in collusion with Birbal Mahato, husband of defendant. इसका रिप्लाई क्या देते हैं? ये WS में पैराग्राफ 16 में काइंडली भी सीन पर इसी पर्पस के लिए पढ़ रहे हैं.
So इसका प्लेंट का पैरा 11 लिखना.
हाँ, प्लेंट का पैरा 11 10, 11, 12 का एक साथ पैरा 16 में WS में रिप्लाई है. That the statement and allegations contained in paragraph 10, 11 and 12 of the plaint are absolutely false, mischievous and motivated and concocted for the purpose of this suit and are denied by this defendant. This is the only statement.
और क्या बोलूं?
नहीं, स्पेसिफिक स्टेटमेंट कि इस दिन ऐसा कोई घटना नहीं हुआ था ऑन पर्टिकुलर डे.
Deny, straight away deny कर ही रहे.
हाँ, स्ट्रेट अवे डिनाई कर रहे हैं बाय कॉमन स्टेटमेंट. और फर्स्ट अपील कोर्ट के जजमेंट में हम प्लेस कर रहे थे पेज 9.
Page 9.
पेज नंबर 9 इंटरनल पेज जजमेंट मतलब अपीलेट कोर्ट का इंटरनल पेज जजमेंट पैराग्राफ पेज 9 सब क्लॉज 4 रोमन 4 सबसे लास्ट पैराग्राफ. That issue was raised before appellate court. Issue has been also been taken up by the first appellate court, but issue has not been framed to decide. The first appellate court has not framed the issue, but answer has been given subsequently. उसी
That
का
the
लास्ट
learned court should have relied upon.
हाँ, उसी का लास्ट पेज का 2 लाइंस के साथ नेक्स्ट पेज का 2 लाइंस पढ़ना चाह रहे थे, उसमें प्लेस किए थे. Scheduled land of plaintiff as sale deed was executed without consideration and without permission from the, इसी पॉइंट पर हार करना चाह रहे थे, permission from the डिप्टी कमिश्नर सरायकेला खरसामा as both the parties belonging to OBC category. इसी में लॉर्डशिप का वो था कि फाउंडेशनल फैक्ट के अब्सेंस में ऐसा नहीं हो सकता है. ये इसी का नेक्स्ट पेज 11 में पैराग्राफ 11 का लास्ट 3 लाइंस है कंसीडरेशन. It is argued that sale deed, इंटरनल पेज 11 का पैराग्राफ 12 जहाँ लिखा हुआ है उससे 3 लाइन पहले से पढ़ रहे हैं. It is argued that sale deed was executed without consideration amount and without permission from the deputy commissioner as both parties belong to OBC category. Paragraph 13, page 13. On perusal of oral and documentary evidence as well as judgment, I find that the issue number 4 decided in favor of plaintiff against the defendant, wherein learned trial court pleased to mention that said sale deed is barred by section 46 of CNT Act as both the parties related backward class and no previous sanction of deputy commissioner has been obtained for execution executing the said sale deed by sale deed number 3640 dated so and so. But he denied about receiving of constitutional format. Agreement, Indian Contract Act has also been taken into consideration at page 15, paragraph 14, while deciding the issue. Under intoxicated condition, the seal deed was executed, therefore it was not valid contract, therefore void an issue as per section 2G होना चाहिए, लेकिन यहाँ 2H लिखा हुआ है मिडिल पैराग्राफ में, पेज 15 का मिडिल पैराग्राफ एट फर्स्ट जहाँ शुरू हो जाता है. At first it is necessary to see the nature of void seal deed. An agreement or document that is not enforceable by law is said to be void under section 2G होना चाहिए of the Indian Contract Act. और जो रिलीफ उन्होंने ट्रायल कोर्ट ने एक्सटेंड किया कि 2,50,000 रुपये रिटर्न कर दीजिए, that was based upon the provision of section 19A which has subsequently been amended.
यहाँ पे जो कॉन्ट्रैक्ट एक्ट का वॉइड है, फॉरबिडन बाय लॉ, if permitted would go against law. Fraudulent, इसमें intoxication कहाँ है?
Intoxication इसमें है ना, कॉन्ट्रैक्ट एक्ट.
कौन सा वाला क्लॉज बताइए कॉन्ट्रैक्ट एक्ट.
कॉन्ट्रैक्ट ही डिफाइंड है कि फ्री स्टेट ऑफ माइंड इज
तो
रिक्वायर्ड.
जरूरी है कि जो आदमी पिया हुआ हो उसका फ्री स्टेट ऑफ माइंड नहीं.
इट इज प्रिजम्पशन अंडर द
वो प्रिजम्पशन दिखा that if a person has a little or more or whatever alcohol, then he will not be in a right state of
फिट स्टेट ऑफ माइंड.
fit state. कौन सा प्रिजम्पशन है कॉन्ट्रैक्ट एक्ट? इंटॉक्सिकेशन में
वो
there is
तो
a
मेरा
presumption.
सबमिशन, वो तो मेरा सबमिशन है.
सबमिशन से नहीं चलेगा ना, लॉ दिखाइए.
मैं 2G का दिखाना चाह रहे हैं कि
दिखाइए 2G में कहाँ लिखा है इंटॉक्सिकेशन?
an agreement not enforceable by law is said to be void.
पढ़िए 2G पढ़िए.
An agreement not enforceable by law is said to be void.
हाँ तो बताइए ना, void agreements भी तो डिफाइंड है ना.
हाँ, void agreement भी defined है. वाइडेबल का 19 है, सेक्शन 19. कंसेंट के लिए सेक्शन 13 इम्पोर्टेंट. कंसेंट किसकी सिचुएशन में हो. Consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. Free consent, section 14, defines consent is said to be free when it is not caused by coercion, as defined in section 15, undue influence, as defined in section 16, fraud, as defined under section 17, and misrepresentation, as defined under section 18 or I mistake subject to the provision of section 20, 21, 22. सेक्शन 19A इसलिए प्लेस कर रहे थे कि ट्रायल कोर्ट हैज पास्ड ऑर्डर विद रिस्पेक्ट टू रिटर्न ऑफ मनी कंसीडरिंग दिस प्रोविजन एंड सेक्शन 33 ऑफ स्पेसिफिक परफॉर्मेंस. Section 19A, power to set aside contract induced by under influence. When consent of an agreement is caused by undue influence, the agreement is a contract voidable at the option of the party whose consent was so caused. Any such contract may set aside, either absolutely or if the party whom was entitled to avoid it has received any benefit thereunder upon such term and condition as the country court may deem fit. Considering this provision, court has directed the plaintiff to return the consideration amount. Section 33 of specific performance of contracted specific relief act, उसमें भी more or less यही provision है. Power to require, I am placing section 33.
कैश पैसे दिया होगा ना,
हाँ?
कैश पेमेंट है ना,
कैश, हाँ कैश पेमेंट ही लिखा हुआ.
रजिस्ट्रार के पास.
हाँ यही तो लिखा हुआ सेल डीड में, तो रिसाइटल ऑफ सेल डीड में यही.
तो रजिस्ट्रार तो पूछते हैं ना पैसा मिला नहीं मिला.
हाँ
उसके बाद
फॉर्मेलिटी,
उसका सेल डीड में लिखाता भी है
सेल डीड में
कब
लिखा
कैसे
है.
पेमेंट हुआ.
नहीं, सेल डीड में तो जनरल स्टेटमेंट है कि पैसा दी, और
उसके
रजिस्ट्रार ये
बाद
पूछता है कि आपने पैसा पाया या नहीं. बेसिकली यही पूछता है.
रजिस्ट्रार को नहीं दिख रहा था एकदम किए हुए, उसको पता नहीं चला.
वो तो वहाँ रजिस्ट्री ऑफिस में तो 30 सेकंड के लिए 3 सेकंड के लिए ऐसे ही लोग जाते हैं, इससे ज़्यादा नहीं.
हम कभी नहीं गए इसलिए हमको कोई आइडिया
नहीं, हम कई बार गए हैं इसलिए बोल रहे हैं कि 3 सेकंड 4 सेकंड. रांची रजिस्ट्री ऑफिस में तो हार्डली सेकंड में कौन कौन लोग हैं नाम पुकारेगा, हाथ उठाइए बस हो गया जाइए, ये भी नहीं पूछना है, लेकिन यूजुअली पूछा जाता है.
ठीक हो गया. आपको कुछ बोलना है?
एडमिशन अपील
आपका अपील मेमो कौन सा है?
7 of 2015.
7 of 2015 का दिन था. 7 of 15 मेमो ऑफ अपील फर्स्ट एक्ट 7 13 of 15.
Year 7 of 2015.
In page 4, ground D of memo of appeal 7 of 2015.
Appeal is never filed on affidavit.
Only certificate is there.
On this certificate.
And downside,
Appeal is never found on affidavit that you will be estoppel against it. That it is an admitted.
Certificate was duly given.
Certificate is given by the advocate.
Verification
Always- नहीं,
verification.
even verification is not there in memo. It only has वकालतनामा.
वो तो यहाँ भी है. दो
सभी जगह है. अपील कभी एफिडेविट में फाइल नहीं होता.
नहीं, यहाँ 2 फॉर्मेट है हाई कोर्ट में. एक फॉर्मेट में है along with एफिडेविट, और एक
ऐसा कोई फॉर्मेट है नहीं.
2 फॉर्मेट में
मेमो ऑफ अपील में अगर कोई फैक्ट्स आप देते हैं तब आपका एफिडेविट चाहिए, और अगर कोई फैक्ट आप नहीं दे रहे हैं, बीइंग एग्रीड से लिख रहे हैं, तो कोई ना एफिडेविट चाहिए ना वेरिफिकेशन चाहिए, कुछ नहीं चाहिए.
एक फॉर्मेट में ये फाइल होता है जिसमें सिर्फ स्टेटमेंट दे दिए कि बीइंग एग्रीड एंड डिससैटिस्फाइड एंड ग्राउंड सपोर्टेड विद एफिडेविट.
यही है, इसमें भी
सपोर्टेड
है.
विद एफिडेविट. और सेकंड फॉर्मेट ये है जो यहाँ फाइल हम लोग कर रहे हैं, उसमें ये है
आप
कि
जितना फर्स्ट अपील सेकंड अपील फाइल किए हैं ना,
हाँ.
उससे ज्यादा हम देख चुके हैं.
नहीं बिल्कुल रेडी.
आई विल नॉट से कि हम इतना फाइल किए हैं.
नहीं ये हम नहीं कर रहे हैं. हम कह रहे हैं दो तरह का फाइलिंग यहाँ हो रहा
नहीं
है।
नहीं वो
एक सपोर्टेड विथ
नॉट रिक्वायर्ड, जबरदस्ती आप
not
एफिडेविट
required,
दे दीजिए,
not
इसका कोई
required।
मतलब थोड़ी है,
बोल तो रहे हैं, हम
नॉट
भी बोल ही रहे हैं
रिक्वायर्ड, और
कि
इसमें भी नहीं है,
This memo of appeal is not affidavit.
नॉट एफिडेविटेड, कुछ नहीं है इसमें।
तो उसमें एक alternative ground लिया गया था कि if at all it has ground that both parties are belonging to, then permission के लिए भेज दिया था. That was the only ground. That is a ground also, not submission or.
मेरा जो अभी फाइल हुआ था वहाँ फर्स्ट अपील कोर्ट में 13 जो नंबर है, दैट वाज सपोर्टेड विथ एफिडेविट।
आपका अपील का तो बात ही नहीं कर रहे हैं ना,
हम भी फर्स्ट
आपका
अपील
इनका तो सेटिसाइड हो ही गया था, आप तो रिफंड के अगेंस्ट में गए,
जो भी गए तो वहाँ फर्स्ट अपील कोर्ट में सपोर्टेड विथ एफिडेविट था मेरा।
उससे कोई मतलब नहीं, क्योंकि यू वर एग्रीड बाय द अदर पार्ट ऑफ द जजमेंट, यू वर एग्रीड बाय द रिफंड पार्ट ऑफ द जजमेंट।
हाँ, for that we have referred appeal
so far as
supported
they
with
are
affidavit।
concerned, so far as they are concerned, it is not supported by any affidavit, not at all.
यही मेरा सबमिशन है कि मेरा जो अपील फाइल हुआ वो दैट वाज सपोर्टेड विथ एफिडेविट
हाँ,
15।
ठीक है, उससे क्या मतलब है,
उससे
इंटॉक्सिकेशन
ये-
का चाहे
कास्ट का
भी कोई मतलब नहीं।
कास्ट का इसलिए मेरा सबमिशन ये था कि वो दोनों लोग या खुद अपीलेंट जो डिपेंडेंट हैं, डिपेंडेंट वाज अपीलेंट बिफोर फर्स्ट अपील कोर्ट एंड हियर इन आल्सो ही इज अपीलेंट, तो इनका कहीं भी फाउंडेशनल फैक्ट में ये डिनायल नहीं है कि वी आर नॉट, आई एम नॉट बिलोंगिंग टू कुर्मी कास्ट और नॉट बिलोंगिंग टू ओबीसी। मेरे लिए नहीं स्टेटमेंट देते वो तो चल रहा, अपने लिए भी कहीं स्टेटमेंट नहीं दिए हैं। क्या स्टेटमेंट है वही प्लेस कर रहे थे, थोड़ा पेज 4 में ग्राउंड डी उसी अपील का अपील नंबर 7, टाइटल अपील नंबर 7 का डी पेज 4 मेमो ऑफ अपील। For that the plaintiff in his pleading never pleaded that he being a backward class of people no permission was obtained and therefore ये तो pleading है, but whether the defendant belongs to OBC caste or he is not belonging to OBC caste,
ये भी pleading नहीं है,
ये भी pleading नहीं है,
नहीं है
नहीं
pleading
है, नहीं
that he
है।
belongs to OBC,
नहीं है, ये हम नहीं कह रहे हैं। Issue has already been decided by the trial court. Being aggrieved by that issue, first appeal was preferred to make a denial of that part of judgment lordship. The finding of trial court is wrong, as the party does not belong to Kurmi caste or Mahto. That statement has not been given. It is my submission.
all right, we'll see that. आपका सबमिशन लिखा है, इनका तो कल लिखा है। The learned counsel for the respondents has opposed the prayer and has submitted that even if there was no pleading with regard to the caste status of the parties, the same will not be a reason to decide the substantial question of law in favor of the appellant, inasmuch as the learned trial court has decided the case on the point that the required permission under Section 46 of the Chotanagpur Tenancy Act was not taken. And during the course of arguments, it was not in dispute that both the parties belonged to the caste Kurmi and their surname was Mehto, and therefore they belong to the caste Kurmi within bracket Mehto, which is one of the castes notified under the one of the backward classes notified under Chotanagpur Tenancy Act. Correct? ये submission है?
ये submission भी है and trial court में both the counsels have admitted this fact.
The counsels before the learned trial court had admitted this fact that during arguments that both the parties were belonging to backward class, and therefore the learned trial court had entered into this issue and has found that in absence of the required permission, the sale deed was void ab initio, being violative of the statute itself. So far as the point of intoxication is concerned, the Learned Counsel has referred to the plaint and has submitted and has in particular referred to para 11 thereof, and submits that in the written statement in paragraph 16 there is simpliciter denial of these statements made from para 9 to 11, but no further specification or explanation has been furnished.
Para 10, 11, 12.
Sorry, para 10, 11. The Learned Counsel has also referred to paragraph 19 of cross-examination of the purchaser, namely Anita Devi, who was examined as DW4
Appellate hearing.
and has submitted that in the cross-examination she initially stated that permission from the Deputy Commissioner was taken, and then simultaneously stated that no permission was required to be taken. By referring to this cross-examination, the Learned Counsel has submitted that the purchaser was very much aware of the fact that the point regarding permission from the Deputy Commissioner as required under Section 46 of Chotanagpur Tenancy Act was being considered by the court. The Learned Counsel has also submitted that before the Learned First Appellate Court, or even before this court, the appellant, namely Anita Devi ki Mehto,
Anita Mahato.
the purchaser, namely Anita Mehto, has not denied the fact that that both the parties belong to backward class.
Kurmi. By caste,
They belong to the caste Kurmi,
which is backward caste in Jharkhand.
architecture,
Through clarity, madam.
which
I am sorry.
is backward class. And in the notification, the backward class is termed as, the Kurmi backward class is termed as Kurmi within bracket mein.
Appeal would have been
The Learned Counsel has submitted that this fact has not been disputed even before this court. The Learned Counsel has submitted that so far as the direction to refund the consideration amount of 2.5 lakhs is concerned, the Learned Trial Court had erred in such direction, inasmuch as the specific case of the plaintiff was that the sale deed was fraudulently obtained and under influence of intoxication, and even the consideration amount was not paid to the plaintiff. He submits that when the plaintiff did not receive the consideration amount, there is no question of any refund. with respect to the another sale deed number 3641 on the same day, that is 26/7/2006, in which the plaintiff was the purchaser. The learned counsel has submitted that the same was not under challenge at any point of time, and therefore legality and validity of the same was not under consideration. He has submitted that the plaintiff had stated that the entire consideration amount in connection with sale deed number 3640 dated 26/7/2006 was already paid to the vendor, and therefore it was not correct to say that the money taken by the plaintiff, the money alleged to have been taken by the plaintiff while executing sale deed number 3640 dated 26/7/2006 was utilized by the plaintiff to make payment with regard to his purchase in connection with sale deed number 3640 dated 26/7/2006. The learned counsel has submitted that sale deed involved in the present case being sale deed number 3640 dated 26/7/2006, having been obtained through fraud by intoxicating the plaintiff and in violation of section 46 of Tobacco Tenancy Act and without payment of consideration, has been rightly set aside by the courts. And the direction to refund amount of rupees 2,50,000 has been rightly set aside by the learned first appellate court. He submits that both the second appeals are fit to be dismissed after answering the substantial question of law so framed against the appellant and in favor of the respondent, within bracket plaintiff. That is all. कुछ छूट गया तो बताइए.
अपीलेट कोर्ट का जजमेंट का मेरा सबमिशन था पेज 9.
The learned counsel has referred to the judgment passed by the learned first appellate court at internal page 9, Roman 4, which is dealing with the grounds which was taken by the plaintiff in the memo of appeal before the first appellate court, which was numbered as appeal number 13 of 2015. So ground है, finding थोड़ी, just a ground. और कुछ छूट गया? अब सुनिए जजमेंट. कल बैकग्राउंड आपका पूरा लिखा दिए थे, जो कौन सा था, एवरीथिंग हैज बीन रिटन. the perusal of the records reveal that statute number 47 of 2008 was filed by Deven Mehto by caste Urmi by Faith Hindu against Anita Mehto seeking cancellation of SAILI number 3640 of 2006 dated 26/7/2006. As per the plaint, the plaintiff and defendant were known to each other, but the defendant and her husband had greedy eyes on the landed property of the plaintiff. And her husband used to visit the house of the plaintiff and used to give allurement and assurance. On the alleged date of registration of the suit property, the plaintiff was served with wine and country-made liquor, and he was in intoxicating condition and was brought to Saraikela, and his thumb impression were taken in various papers, though he usually signs and writes his name as D.N. Mehto, but he was prevented to sign any paper. It was his further case that the content of the deed were also not read over to him, nor was explained to him in local language. And he was also advised to give affirmative answer before the sub-registrar and not to give any negative answer. It was alleged that the thumb impressions were fraudulently obtained by Gagan Sao in collusion with Birbal Mehto, the husband of the defendant, and that the plaintiff had no knowledge regarding transfer of his property in favor and that the plaintiff was not even paid a single rupee, nor there was any legal necessity to sell the land. These facts have been mentioned in the plaint from particularly in paragraph 7 to 12. The plaintiff came to know, as per the plaintiff came to know after some years from the people in the locality that his property has been purchased by the defendant for a consideration amount of rupees 2,50,000. And ultimately the suit was filed alleging fraud. After obtaining the certified copy of the sale deed, which the plaintiff received on 4/10/2008. The perusal of the plaint reveals that the suit was filed alleging fraud in as much as the plaintiff was in an intoxicated state at the instance of the husband and one Gagan Mehta, and that no consideration amount was paid to the plaintiff, and he was in the intoxicated condition he was made to put his thumb impression in various papers, though he used to sign his name as DNB. The perusal of the plaint reveals that there is no whisper regarding any violation of the provisions of Section 46 of the Tobacco Tenancy Act, nor it is disclosed in the plaint that the plaintiff belongs to backward class. A written statement was filed by the defendant denying the allegation and the allegation made in paragraph 7 was specifically denied by stating that the plaintiff had himself approached for transfer of the suit land as he was in need of money and adequate consideration was paid. With respect to paragraph 8 of the plaint, the allegation was again denied, and the defendant stated that plaintiff is his own Mosa, that is mother's full sister's husband. And due to such relationship, defendant used to visit the house of the plaintiff occasionally, and they were still in visiting terms. With respect to para 9, it was the allegation regarding service with wine and country-made liquor, and that he was brought in an intoxicated condition to Saraikela on the date of registration, and his thumb impression was taken on various papers, and that he was prevented to sign any paper were said to be false, mischievous, motivated, and were denied. It was also stated therein that the plaintiff was silent in his plaint as to who allegedly served him with wine and country-made liquor and who prevented him to sign any paper. It was also asserted that the plaintiff was in a free state of mind and in a sound health and received full consideration of money from the defendant on 26/7/2006 at Saraikela, and on his direction the registered sale deed dated 3640 number 3640 dated 26/7/2006 was scribed by the scribe unto Sundi, and thereafter contents of the said deed was read over and explained to the plaintiff. And finding the same correct, the plaintiff had put his LTI on all the pages and also put his 5-finger impression of the left hand in the sale deed and duly executed the sale deed before the district sub-registrar Saraikela, and he was identified by Uttu Mehto of village Gamaria, and thereafter the plaintiff delivered the possession over the suit land to the defendant. It was also stated that the plaintiff could sign his name as D.N. Mehto, but at the relevant period and time, he preferred to put his LTI. The statements made in paragraph 10, 11 and 12 of the plaint was denied in paragraph 16 as being false, mischievous and motivated. It was further stated in the written statement that on the direction of the plaintiff, the defendant purchased the non-judicial stamp paper. Thereafter, plaintiff came to Saraikela on 26/7/2006, received full consideration amount from the defendant and her husband, Birbal Mehto. And 2 persons, namely Uttu Mehto and his full brother Tilak Mehto, both came along with the plaintiff, and on the instructions of plaintiff, the scribe unto Sundi drafted the sale deed number 3640 dated 26/7/2006, which was read over to him, and then the deed was executed. The plaintiff was identified by Gagan Sahu. It was also asserted that after the registration of the sale deed, the plaintiff endorsed the registration receipt in favor of the defendant for getting the original sale deed, and accordingly the defendant got the original sale deed from the sub-registry office. And subsequently the property was also mutated in the name of the defendant under full knowledge of the plaintiff. A plea was also taken in the written statement that after receipt of the full consideration or amount of rupees 2,50,000, the plaintiff on the same day purchased property from Tilak Mehto and got it registered by sale deed number 3641 dated 26/7/2006. And the amount so paid by the defendant was utilized by the plaintiff for payment of the consideration amount. It was also stated in the written statement that the sale deed also contained the photograph and was attested by the deed writer unto Sundi. And Uttu Mehto, the full brother of the vendor, and Tilak Mehto identified the vendor before the district sub-registry office. Uttu Mehto identified the witness, Gagan Sao, and had also put his signature on the CD. It was asserted that the execution of the sale deed number of the other sale deed bearing sale deed number 3641 dated 26/7/2006 on the same day was itself prima facie to show prima facie that the plaintiff was in free state of mind and sound health, and upon receipt of the consideration amount from the defendant, he paid the consideration amount in the other sale deed. The learned trial court framed from the perusal of the written statement also, it is clear that nothing was mentioned regarding the caste of the parties, nor there was any mention regarding any permission having been taken from the Deputy Commissioner. This court finds that from the plain and the written statement, this court finds that the parties did not join issue regarding requirement of permission from the Deputy Commissioner or regarding their caste status, and no plea was raised regarding violation of Section 46 of Totonaco Tenancy Act, which provides that for transfer of land of backward class as notified, the required permission is required to be taken from the Deputy Commissioner. The learned trial court framed the following issues for consideration. Which are as follows. Quote करना है. However, from the perusal of the issues as framed by the learned trial court, no issue was framed as to whether the sale deed was in violation of the provisions of Section 46 of Totonaco Tenancy Act. The learned trial court, by considering issue number 4, that is whether the sale deed number 3640 dated 26/7/2006 was duly executed by the plaintiff, recorded the submission of the counsel for the plaintiff that the sale deed was executed by plain fraud. The learned trial court also recorded that the admitted position was that the plaintiff and defendant are relatives. The learned trial court recorded that the main contention of the plaintiff was
that there is admitted fact that both the parties to the suit are members of backward class and both are guided by the provisions of section 46 within bracket 1 within bracket B of the CNT Act. And the counsel for the plaintiff had argued that a member of backward class can transfer their holding to another backward class person who are residing in the same under the same police station, and the permission under section 46 within bracket 1 within bracket B of the Chotanagpur Tenancy Act is to be obtained from the Deputy Commissioner, which is mandatory. The plaintiff, it was recorded by the learned trial court that the plaintiff in course of argument and even in the written notes of argument strongly relied upon the provisions of section 46 within bracket B 1 within bracket B of Chotanagpur Tenancy Act and had submitted that in absence of the permission from the Deputy Commissioner, the alleged sale deed cannot be validated, and therefore the sale deed was void ab initio and not binding on the plaintiff. It was also recorded by the learned trial court that regarding the pleading of law in the plaint that the execution of sale deed is in violation of Chotanagpur Tenancy Act, it was submitted by the plaintiff's counsel that it is settled principle of law that the pleading of law is not required to be made by the parties in the plaint. The aforesaid recording of the learned trial court in paragraph 7 while deciding issue number 4 clearly reveals that, yes, you have to go.
We actually wanted to make a submission on behalf of the association. We had written a letter to the High Court, Your Lordship, because Honorable the President is coming, Your Lordship, some road block.
No other case will be taken up if they are. If you want to stay, I just don't know. If anybody wants to stay, I will just.
We are here.
After this order,
ये तो लंबा चलेगा मैडम. सेकेंड अपील फर्स्ट अपील का डिक्टेशन कितना लंबा चलता है, रीड थोड़ी है. इस केस के बाद कुछ ऑर्डर्स के मैटर हैं.
उसको जो कल रख दिया जाता है या मंडे को रख दिया जाता है.
ठीक है, कल कर दीजिए. कुछ ऑर्डर्स के सप्लीमेंट्री में है मैटर्स, उसको सेग्रीगेट कर दीजिए. सम ऑफ द केसेस रॉन्गली लिस्टेड करके उसको उस डेट में डाल दीजिए और जो वाले मैटर्स लिमिटेशन पर हैं उसको डाल दीजिए. कोई है काउंसिल, कौन थे रेस्पोंडेंट की तरफ से?
एक मैटर 4:15 बजे के लिए
4:15 बजे के लिए कौन
फाइनल डिस्पोजल हो रहा है, जजमेंट की फाइल हम लोगों से जस्ट पहले कॉल बताएंगे.
वो सेव हो गया, वो हो गया उसमें. ठीक है मैडम, आई टेक केयर, आई जस्ट ऐसा है. आप लोग को जाना है, आप लोग जा सकते हैं. हम लिखाना शुरू किए हैं, हम लिखा के उठेंगे. आई डोंट नीड एनी वन ऑफ यू बिकॉज आई मेड अप माई माइंड. आई हैव सीन ऑल द रिकॉर्ड्स. नोबडी इज रिक्वायर्ड.
हम लोगों का तो इधर ही है, हम लोग कोई इशू नहीं है ट्रैफिक का.
I don't know. You are here, it's okay. Everybody is free to go and no other matter will be taken. Paragraph 7 of the learned trial court's judgment clearly revealed that the point regarding violation of section 46 within bracket 1 within bracket B of Chotanagpur Tenancy Act was raised by the counsel for the plaintiff by stating that the same was a point of law and for that purpose no foundational pleading was required. The learned trial court ultimately the learned trial court also recorded the argument of the defendant's counsel, who objected to the submissions made by the counsel for the plaintiff and had submitted that the counsel for the plaintiff at the back end of the argument and for the first time gave a memorandum of argument on law point that since both the parties are OBC, therefore sale deed is not valid in the eyes of law and that plea cannot be accepted. And that no such pleading was raised by the parties. And also stated that in case and also stated that the deputy commissioner was not made a party in the proceedings. The learned trial court recorded that though the plaintiff, in paragraph 9, that though the plaintiff and the defendant argued on facts, but for last several dates, both confined their arguments to the provision of Chotnagpur Tenancy Act. And it appeared to the learned court from the written notes of argument as well as the authority cited by both the parties that they had confined themselves on the provision of Chotnagpur Tenancy Act relating to the main question whether the alleged sale deed was in violation of section 46 of the Chotnagpur Tenancy Act. Thereafter, the learned trial court proceeded to decide the case regarding the validity of the sale deed, primarily on the basis of section 46 of Chotnagpur Tenancy Act. And observed that the pleading of law is not to be made in the pleadings. The plaintiff in the plaint had stated that his caste was Kurmi and the defendant never objected. It was also observed by the court that the law is not required to be pleaded and only facts are required to be pleaded. The question of law in the present case does not depend on the determination of any question of facts, as admitted by the parties are backward class, so the question can definitely be adjudicated. Page 7 का internal page 7 का इसको quote करना है. The relevant portion is quoted as under. The learned trial court also considered the cross-examination of DW4, the defendant herself, at paragraph 18, wherein she stated that she had obtained permission and again stated that at that time no permission was required. The learned trial court ultimately held that the sale deed number 3640 dated 26/7/2006 was not duly executed by the plaintiff in favor of the defendant, as it was in violation of the legislative mandate of obtaining sanction of the Deputy Commissioner prior to sale. This court finds that the learned trial court decided the entire issue number 4 only on the point of violation of section 46 of the Chotanagpur Tenancy Act. There is no finding that he was in a state of intoxication. The entire discussion does not reveal that any finding was ever recorded by the learned trial court that the defendant was in a state of intoxication or that the consideration amount was not paid to the defendant, which were the main issues raised by the plaintiff in the plaint to challenge the sale deed. The learned trial court held that, while deciding issue number 5, held that the plaintiff was in possession of the suit property as in case of void sale, the possession also cannot be recognized. While deciding issue number 6, the learned trial court held that the defendant does not acquire any right, title and possession arising out of sale deed number 3640 dated 26/7/2006. While deciding issue number 1 and 2, the learned trial court held that since the deed was executed without permission of the Deputy Commissioner, a shadow was cast over the title, and therefore the plaintiff had a valid cause of action to institute the suit, and therefore the suit was maintained. While deciding issue number 3 on the point of limitation, waiver, estoppel, acquiescence, it was observed that the period for cancellation of deed is 3 years, and the suit was filed within 3 years from its execution. Therefore, the suit was not barred by limitation. While deciding issue number 7, the learned trial court was of the view that while cancelling the document, the plaintiff needs to surrender the actual benefit received under the transaction, which is avoided, and consequently directed the plaintiff to refund the entire consideration amount of the LS sale deed amounting to rupees 2,50,000. Thus, the learned trial court declared the sale deed as inoperative, void, illegal and not binding on the plaintiff, on the ground that it was violative of the provisions of section 46 of Chotanagpur Tenancy Act. However, the execution of the sale deed and payment of consideration was not disbelieved, and consequently no finding was recorded in that connection. and the learned trial court directed for refund of rupees 2,50,000. Both the parties were aggrieved by the judgment of the trial court and filed their respective appeals. The appeal filed by the plaintiff challenging the refund of rupees 2,50,000 was numbered as title appeal number 13 of 2015, and so far as the defendant is concerned, her appeal was numbered as title appeal number 7 of 2015. The learned first appellate court point of determination कहाँ है? Any point of determination framed?
Point of determination, issue wise,
All issue wise it was considered. The learned first appellate court also considered all the issues and case of the respective parties. And observed in paragraph 13, that the court had perused the oral and documentary evidence as well as the judgment impugned. The learned trial court recorded, the learned first appellate court recorded a finding that the point of determination para 14 में लिखिएगा, para 14 से quote करना, which are as follows: A, whether the LA sale deed is barred by law and same is void sale deed. B, whether any relief for getting consideration amount has been sought. Whether same is a part of the pleading of the plaintiff. Comma, whether plaintiff admitted about consideration amount in oral evidence and whether any cross suit was filed by the defendant. The learned first appellate court upheld the judgment of the trial court on both the grounds. That is, on the ground of violation of section 46 of Jharkhand Tenancy Act, and also on the ground of alleged intoxication of the plaintiff prior to execution of the sale deed. The finding of the learned Trial Court, the first appellate court, at paragraph 19 is quoted as under. यहाँ तक पहले quote करेंगे. The learned first appellate court, while deciding issue number 7, was of the view that the plaintiff was treated in intoxicated state and the defendant had obtained thumb impression on the seal deed, and the plaintiff neither sold his land nor taken consideration amount. And ultimately held that the direction to refund cannot be sustained. Therefore, that part of the review of the trial court by which a direction was made to refund rupees 2,50,000 was set aside. The findings are as follows. Para 20 maybe is the issue number 7 page of finding. This court finds that the learned first appellate court recorded that while considering section 46 of Chotanagpur Tenancy Act, recorded that it was admitted by the parties that both belonged to backward class. And therefore, in absence of permission under section 46 of Chotanagpur Tenancy Act, the defendant did not acquire any right, title and interest over the suit property. This court finds that while recording the aforesaid findings, that both the parties admitted that they belong to backward class, the learned first appellate court has not taken note of the fact that there was no foundational pleading in the plaint and the written statement in connection with the social status of the parties, and there was no plea that the sale deed was executed in violation of section 46 of Chotanagpur Tenancy Act. The learned trial court has also not taken into consideration, has also failed to observe that the learned first appellate court also failed to observe that the learned trial court had decided the said point in spite of observing that there was no foundation plea, and such plea was raised during the course of argument and in the written submissions filed by the plaintiff, by the counsel for the plaintiff, by observing that the same is a point of law and no pleading is required. While answering the substantial question of law, number 1, this court finds that the findings of the learned trial court as well as the learned first appellate court in connection with violation of Section 46 of Tobacco Tenancy Act, in connection with applicability of Section 46 of Tobacco Tenancy Act and its violation is not based on any pleading whatsoever. The trial court was of the view that no pleading was required to advance arguments with respect to Section 46 of Tobacco Tenancy Act, and the learned first appellate court has not referred to the foundational pleading of the respective parties while deciding this issue and proceeded under the assumption that it was an admitted fact between both the parties. The question of admission arises only through pleadings, which are essentially the plaint and the written statement. And in case any fact is required to be brought on record, the same can be brought on record by amending the plaint. The written submissions filed before the court and the arguments advanced on behalf of the parties do not constitute a part of pleading. Rather, written submissions which are not based on foundational pleading by itself is of no consequence. This court is of the considered view that the observation of the learned trial court that in order to raise such a plea regarding objection under Section 46 of Tobacco Tenancy Act, no pleading was required, is itself perverse, inasmuch as in absence of foundational pleading regarding the status of the parties and in absence of specific challenge in connection with alleged violation of Section 46 of Tobacco Tenancy Act, and in absence of any issue framed in that regard, merely by taking such a plea through the written notes of argument and during the course of argument, such a plea could not have been entertained. The allegation regarding violation of Section 46 of Tobacco Tenancy Act is not a pure question of law. Rather, it has to be appreciated on the basis of foundational fact, which is not only required to be pleaded but is also required to be proved. In view of the aforesaid findings, this court is of the view that both the learned courts erred in travelling beyond the pleadings and consequently travelled and consequently the findings in connection with applicability of Section 46 of Tobacco Tenancy Act is perverse, being based on no foundational pleading. The substantial question of law number 1 is framed in essay number 34 of 2023 is accordingly decided in favor of the appellant and against the respondent. So far as substantial question of law number 2 is concerned, this court finds that the learned trial court did not record any finding with regard to the allegation made in the plaint that the plaintiff was under intoxication and that no consideration amount was paid by the plaintiff and he was forced to put his thumb impression before the registry office while executing the sale deed number 3640 dated 26/7/2006. The defendant had raised a specific plea that on the same day another sale deed was executed in favor of the plaintiff of the case, which was numbered as sale deed number 3641 dated 26/7/2006, in which he paid the consideration amount of rupees 3 lakhs. The defendant had taken a specific plea that the plaintiff had taken a specific plea in the written statement at paragraph number 23 that the 22 and 23 the paragraph number 21 onwards. Yes, paragraph 21 onwards, giving in detail the manner in which the two sale deeds bearing sale deed number 3640 dated 26/7/2006 and sale deed number 3641 dated 26/7/2006 were executed one after another, to submit that the plaintiff was in a free state of mind and to further demonstrate this fact, various aspects of the matter were pleaded in the written statement. For that purpose, it would be required to go into the evidence of the for that purpose, it is important to note that the plaintiff in his plaint has categorically stated in has categorically the PW3 is Antu Sundi, who is a scribe of both the sale deeds, that is 3640 dated 26/7/2006, and also the sale deed which is the subject matter of the present case, and also sale deed number 3641 dated 26/7/2006. He in his evidence has stated that he had typed the sale deed number 3640 dated 26/7/2006. No, written and typed the. He had written the sale deed, and Prakash Sahu had typed the same. He has stated that at the time of making the sale deed on 26/7/2006, the plaintiff was drunk and was not in a position to walk, and the husband of the plaintiff, namely Birbal Mehto, and at the instance of one Gagan Sahu, the plaintiff had put his thumb impression on the deed, and thereafter Gagan Sahu had identified the plaintiff, had put his signature. However, during his cross-examination, he has stated that Prakash Sahu had typed the deed under his instructions, and the deed was read over to the seller, that is the plaintiff, and thereafter this witness had put a certificate on the sale deed, and then he had rectified the deed. He has also stated that on the same day he had prepared the other sale deed bearing number 3641 dated 26/7/2006 under the instruction of the seller, namely Trilok Mehto, in favor of Devendra Mehto, the plaintiff in the present case, and he read over the deed, and thereafter the witnesses had put their signature, and he also gave the certificate and put his signature on the deed. This witness has exhibited the exhibit A and A/1 at the stage of cross-examination. He has stated that, he has further stated in his examination that thereafter he had taken all of the parties to the registry office before the registrar, and ultimately the deed was executed. He has also stated that the plaintiff of the present case, Devin Netu, had purchased the property through the other deed, number 3641, on the same day by paying rupees 3 lakhs. And in both the sale deeds, the witnesses are the same. In both the sale deeds, that is sale deed number 3641 and 3640, both dated 26/7/2006, the witnesses are also the same. In his further cross-examination at paragraph 11, he has stated that Devin Mehto had himself walked down to the registry office. The PW3 during his evidence has in fact supported the due execution of the sale deed. Though he has stated that though he has stated in his evidence in chief that the plaintiff was drunk, on 26/7/2006. At the same time, he stated that the plaintiff was not in a position to walk and he was being held by the husband of the defendant and one Gagan Sahu. But during cross-examination, he has stated that the plaintiff had himself walked down to the registry office. The plaintiff himself has been examined as PW4. He has stated that he was forcefully taken, that he was kept under intoxication right from the morning, and was forcefully boarded on a vehicle, on a car, on a vehicle, and was forcefully made to put his thumb impression on the seal deed. He has stated that he was not in a position to walk under intoxication and he was not in his senses. He has further stated that he always used to put his signature and not thumb impression. With respect to the payment of consideration amount, which is in connection with the other sale deed, that is 3641, this witness has stated that he had already paid the consideration amount. However, the exhibit 1 is the document regarding agreement of sale with respect to which ultimately culminated in the sale deed bearing 3641 of 2006, which reveals only part payment of consideration amount and the remaining was to be paid at the time of execution of the sale deed. The exhibit 1 reveals that at the time of agreement, rupees 4,000 was paid. Out of the पता नहीं चल रहा है इसका हटा दीजिए। ये इसी से रिलेटेड है ना 8641 कंसिडरेशन अमाउंट नहीं पता चला। On a consideration of 86, इतना कम consideration amount है तो मैच नहीं करता।
It was prepared in the year 1986.
84, 5684.
94.
5684. The agreement is of the year 5 on is dated 5684, wherein the consideration amount has been shown only as rupees 8960 and 4,000 was said to be paid in advance. Admittedly, the consideration amount of the subsequent deed, that is 8641, was rupees 3 lakhs as per the deed and exhibited before the learned court. PW4 has also been fully cross-examined. has stated in paragraph 32 that he did not take any money arising out of the agreement dated 5/6/84, and in paragraph 33 he has stated that he had come to the registry office for registering the deed in favor of Trilok Mehto, and that Trilok Mehto was paid the money on the date of registry, and that the brother of Trilok Mehto, Suku Mehto and Gagan Sao were the witnesses. He has stated in paragraph 34 that he and Puttu Mehto and other witnesses, all of them had come to the registry office and all of them executed the sale deed number 3641 dated 26/7/2006, and in the sale deed he had not put his signature but he had put his thumb impression. Further, in paragraph 35 he has stated that so far as sale deed number 3640 dated 26/7/2006 is concerned, he had executed the same in favor of the defendant Anita Mehto, and then he himself stated in paragraph 35 itself that he has not executed the sale deed number 3640 in favor of anybody, though he had come to the registry office on that day. And his thumb impression was identified by Puttu Mehto, who had identified him before the registry. He has stated in paragraph 36 that he got the sale deed executed from Trilok Mehto in the registry office for an amount of rupees 3,300 लिख रहा है, लेकिन ऐसा नहीं। In paragraph 38, he has stated that in his complaint he has mentioned that the defendant on 26/7/2006 got his thumb impression done, and therefore he has stated that he does not give thumb impression but he puts his signature. He has also stated in cross-examination that his photograph is affixed on the sale deed number 3640 dated 26/7/2006. The cross-examination of PW4, who is the plaintiff himself, reveals that he had executed the sale deed number 3641 dated 26/7/2006 in full census, and he himself has stated that he had gone to the registry office on 26/7/2006 along with other witnesses and connected persons. And on the same day, he had also executed and admittedly on the same day, the sale deed number 3640 dated 26/7/2006 was executed. His specific evidence is that he was in a state of intoxication right from the morning. In view of the evidence of PW4, who on the one hand has fully supported the due execution of the sale deed number 3641 dated 26/7/2006 under the same witnesses who were also there in sale deed number 3640 dated 26/7/2006. This court is of the considered view that the plaintiff had taken inconsistent stand in connection with execution of sale deed number 3640 of dated 26/7/2006 by alleging that he was in a state of intoxication and was not in a position to understand the nature of things and was forcibly put to execute, forcibly, and his thumb impression was forcibly taken. And on the other hand, with respect to another sale deed of the same day, he had executed the same, one after the another, with full census. This plea was specifically taken by the defendant in the written statement. This is over and above the fact the scribe of both the sale deeds during his cross-examination has also supported due execution of the sale deed and due issuance of certificate, and also the fact that the plaintiff himself walked down to the registry office for the purposes of execution of the sale deed. This court is of the considered view that the learned first appellate court has not appreciated the admitted due execution of sale deed number 3641 dated 26/7/2006 on the same day with the same set of witnesses. Immediately after the registration of sale deed number 3640 dated 26/7/2006, while holding that the sale deed was bad in law on account of intoxication of the plaintiff. Such finding is perverse. It is also important to note that the learned first appellate court, while considering the evidence of PW4, has not considered his cross-examination. The PW3 has not examined his cross-examination, and further the evidence of PW4 has also not been considered in totality, much less his cross-examination. The only aspect of the evidence of PW4 which has been taken into consideration is that PW4 deposed that on the date of registry, foreign liquor was provided to him and he was intoxicated, and on the same day he forcibly brought to Sarikela and his third impression was obtained on various documents. But he used to sign. In view of the aforesaid facts and circumstances, this court is of the view that the execution of sale deed number 3641 dated 26/7/2006 on the same day, though in favour of the plaintiff, in connection with which he has no grievance, and the facts and circumstances in which both the sale deeds have been executed, has a serious bearing in the matter, which has been omitted to have been considered by the learned court. Consequently, the second substantial question of law is also answered in favour of the appellant and against the respondent. So far as the only substantial question of law framed in essay number 49 of 2023 is concerned, this court is of the considered view that having upheld that the trial court did not go into the point as to whether the consideration amount was paid or not. Yes. Having decided the aforesaid issue in essay number 343 of 2023, there is no question of any refund of the consideration amount. To the appellant, who was the defendant before the court, the sale deed, the due execution of the sale deed, the execution of the sale deed number 3640 dated, the sale deed number 3640 dated 26/7/2006 is held to have been validly executed. Consequently, the suit stands dismissed. The judgment passed by the learned first appellate court, upholding the judgment of the learned trial court, are hereby satisfied. Appeal is allowed.